So, dear student, in this new video, we will discuss about different types of arbitration. So, student, there are basically 6 types of arbitration. I'll name out them. They are domestic arbitration, then foreign arbitration, then comes ad hoc arbitration, then institutional arbitration, statutory arbitration, and the last one is international commercial arbitration. So first we will discuss about the domestic arbitration. When can we say that an arbitration is a domestic arbitration? Yes, there are 3 conditions to be fulfilled. The first one is when the arbitration proceedings happened in India. Second condition is both the parties belongs to India. And the third one is the dispute will decide in accordance with the substantial law and procedures followed in India. If these 3 conditions satisfied, we can say that arbitration is a domestic arbitration. Now comes the second one, that is foreign arbitration. Here the arbitral proceeding will be outside India. The parties may be, one may be Indian, the other party may belongs to other country, but the arbitral award is supposed to enforce in India. In these cases, we can say that arbitration is a foreign arbitration. Now comes the third one, that is ad hoc arbitration. In this ad hoc arbitration, the parties are agreed that they will not select any particular institution to administer the proceedings. The institutions like International Chamber of Commerce, London Court of International Arbitration, or Permanent Court of Arbitration, etc. The parties will not select any of these particular institutions to supervise or monitor the proceedings. Then we can say that yes, these arbitrations are ad hoc arbitrations. What is the specialty in this case? In ad hoc arbitration, the arbitration will be done in accordance with the United Nations Commission on International Trade Law. So now comes the institutional arbitration. This institutional arbitration is just opposite to ad hoc arbitration. In ad hoc arbitration, the party is not selecting any particular institution. But in institutional arbitration, the parties are choosing a particular institution for conducting the arbitration, like International Chamber of Commerce, London Court of International Arbitration, or Permanent Court of Arbitration. If the parties are selecting any of these institutions, we can say that arbitration is an institutional one. Then comes the fifth one, that is statutory arbitration. This is an interesting one. Like, see, the parties have no any option. They can only go for arbitration. This is because of any act or enactment. The best example to describe this statutory arbitration is the Defense Act of 1971. According to this act, all the matters related with the army defense of India will go for only the arbitral proceeding. This is the best example to explain statutory arbitration. Then the last one is international and commercial arbitration. Here, yes, one of the disputing party it could be a person or a corporation. It should be from another country or belongs to another country. And in this international commercial arbitration, the other party can be a country too, a foreign country too, as per section 2(1)(f) of the Arbitration and Conciliation Act. So if the arbitration proceedings satisfy these conditions, we can say that arbitration is an international commercial arbitration. Students, now we will discuss about an important landmark case on related with this arbitration. This is Bharat Aluminium Company Limited versus Kaiser Inc. or Kaiser Aluminium Technical Service, and commonly known as Balco versus Kaiser. And first we will look into the facts of the case. So, yeah, between the parties, an agreement executed, and that was on 22 April 1993. And as per this agreement, the Kaiser agreed that yes, we will supply and install a computer-based system at Balco. And in that agreement, the parties added a arbitration clause, and both the parties agreed that if suppose in future if any dispute happened, that dispute will be settled in accordance with the English arbitration law, and the venue of arbitral proceedings will be at London. And later, yes, dispute arose, and proceedings were carried on in London, and the arbitral tribunal passed two arbitral awards, and these were challenged in India under Section 34 of the Arbitration and Conciliation Act 1996. But both the District Court and High Court rejected the appeals of the petitioner. So, normally the Balco had the third option and the final option, that is before the Supreme Court. Thus, the matter came before Supreme Court. In this appeal, the Balco also made a point that whether the Indian courts can pass interim measures. Interim measures means interim, like interim orders we passed in normal conventional methods. The courts of law will pass interim orders before passing any final judgment. Like interim orders in arbitration, we call it as interim measures. So here at the time of appeal before the Supreme Court, the Balco also challenged that whether the Indian courts can pass interim measures under Section 9 of the Arbitration and Conciliation Act 1996. Why they challenged it? Because something had happened while the arbitral proceedings were carried out in London. During the pendency of these arbitration proceedings, the Balco made an injunction application before the District Court of India, and the District Court allowed that application. Then what happened? Yes, of course, the respondent, Kaiser, filed an appeal against the District Court's order in High Court, Bangalore. And what did High Court did? High Court set aside the application and order passed by the District Court. While dismissing or set aside the order passed by the District Court, the High Court pointed out that only the courts of London can pass any interim relief, because the parties agreed that if we go for arbitration, everything will be in accordance with the English law as substantive law. So this matter was also, as I said, this was also challenged by the appellants before the Supreme Court. And what the Supreme Court said? Supreme Court termed two or remarked two important terms: a seat and a venue. Now we will see what is the difference. When the parties agreed that yes, the proceedings will be happening in a foreign country, we call it as a seat. Yes, the Supreme Court also pointed out that, see, if the parties in the agreement they unanimously selected for arbitration, and the arbitral proceedings will be happening in a foreign country, then we call it as a seat. Then it's obvious that the parties are impliedly accepting, yes, we will follow the laws of that foreign country. Then that's why the Supreme Court highlighted that in such a situation, the Indian courts have no any role in that arbitration or award. it cannot exercise its supervisory jurisdiction. Even the Indian courts have no power to grant any interim measures because all the proceedings, the parties clearly agreed that all the proceedings will be happening in outside or in London, and they are agreed to follow the English law as a substantial law. Then the Indian courts have no role to play. But this condition later changed in 2015 amendment, and they made a change that in section 2, a subclause added to section 2, a subclause 2 added, and then now at present, yes, the Indian courts also can grant interim relief even if the arbitration is happening in a seat. Seat means, yes, the arbitration proceedings will be happening in a foreign country. Students in the NCERT test, in the NCERT text, there mentioned two more cases. Just to point out that the remarks made by the Supreme Court in these cases will passing the judgment about the arbitration, and these are the one case is Konkan Railway Corporation Limited versus Mehul Construction Company. While passing this, the judgment in this case, the Supreme Court highlighted or made a remark that yes, the importance or the demand of arbitration proceedings is increasing day by day because there is no any normal delay like what's happening in the conventional court of proceedings. So even in the international dispute also, the people are very well ready to go for arbitration. Then the another case pointed out in the text is that Purus Day Lawsons Limited versus Jindal Exports Limited. In this case also, the Supreme Court made a remark or additional remark while passing the judgment that is the main object of the Arbitration and Conciliation Act is to provide speedy and alternate solution to the dispute. Yes, the normal court of proceedings before the normal court of law is a time-consuming one, costly one, and yes, at the same time, the arbitration proceedings are a bit speedy one and not that much expensive like a conventional one. So the main objective of the drafting the Arbitration and Conciliation Act 1996 is to provide speedy and alternative solution to the dispute. This is just a remark made by the Supreme Court while passing the judgment in Purus Day Lawsons Limited versus Jindal Exports Limited. So while you answering the questions, if you could add all these cases, definitely it will be an advantage.